Do you recall what your own thought processes were as you listened to him?
I thought, why is the Attorney General involved in this? Why is he wanting me to know about this? This is not a state matter, from what I could tell. And I thought it was very suspicious that someone who was the target of a federal investigation was reaching out to the Attorney General of Texas for legal help.
All right. When this conversation was over, and I think you said it was like 20 to 25 minutes.
Yes, sir.
Did you talk to the Attorney General about that subject anymore? On that occasion?
Yes, sir, we did, and on later occasions. But on that day, December 16th, he made comments to me that indicated he was very mistrustful of law enforcement, and he made a comment as to how he felt about how he'd been treated by law enforcement, which was in a negative way.
Did you make plans? Your initial reaction, what did you do with it?
Well, my initial reaction was, this is crazy.
All right. After you, and without going into anything Mr. Maxwell said, what type of reaction did you get from him when he read it?
The same as mine.
Right. So then did you decide not to investigate it at that time?
We hoped to slow walk it and see if the Attorney General would drop it.
Well, why haven't you arranged it before then?
Again, speaking for myself, I thought it was crazy, and I was hoping the Attorney General would drop it. He didn't.
Why did you think it was crazy?
The idea that the state of Texas Attorney General's office would go investigate the federal courthouse, investigate federal agents and also state agents that were task force officers on the raid, and those were agents from the DPS and the State Securities Board, that we would investigate a federal magistrate judge and federal prosecutors was insane. That is something that can be handled by federal authorities, and there's no easy or practical way for state authorities to investigate the type of complaints Mr. Paul was making. Their main complaint that could theoretically have been a state criminal violation was that the Assistant United States Attorney who got the search warrants signed by the magistrate judge had then altered the warrant after it had been signed by a federal judge, which was absolute craziness.
All right, why is that craziness?
Because that would be a felony, that would get you fired, that would get you sent to federal prison.
All right, so why was that crazy? People commit felonies all the time.
They do. I knew the Assistant U.S. Attorney. He used to work in Dallas. He had a stellar reputation. He had very high personal integrity. I'd never seen any indication in Dallas that he would even think of doing such an outrageous thing.
So if their charges are filed against them and they're indicted, then what is the law, what is the practice as to whether they then get the probable cause affidavit?
At some point, that would be unsealed, and the Assistant U.S. Attorney would send a copy of the previously sealed search warrant affidavit to the defense attorney.
But if they are not charged as yet, and not charged at that time, or not charged immediately after, what will happen with the sealed probable cause affidavit, and whether or not that target that you've used the word is entitled to see it until charges are filed?
The target is not entitled to see it until charges are filed. And sometimes charges aren't filed, but they don't get to see it. That's confidential law enforcement investigative material. It's very important that not leak out, because the target could go destroy evidence. He could go intimidate witnesses and do other things to undermine an investigation.
They're talking to you in terms of warrant is presented, judge signs it, and then supposedly the law enforcement people changed to that affidavit?
Yes.
And what was, as you understood it, the contention as to why it was changed?
Their contention was that
microphone.
The magistrate judge had signed it on August the 12th, and they claimed that they had metadata from the documents that showed it had been changed on August the 14th, the day of the first searches. And they claimed that, their theory anyway, which again sounded insane to me, that initially the search warrant had been approved to search for guns and drugs and related items, But after the agents got there and started the search at 9 o'clock, by 11 o'clock, the Assistant United States Attorney was changing the search warrant to a white-collar crime type of search warrant, seeking documents and computer files, bank statements, financial records, things of that nature. And that was insane.
Were they able to offer an opinion as to whether or not that meant the document was changed for the basic things that were contended by Mr. Tall's lawyers?
Well, let me explain it this way.
Let's do it shortly. Let's see how you do.
All right. There are innocent functions that can change metadata that are routinely done. I had evidence those innocent functions were done. Therefore, the metadata theory proved no wrongdoing. It proved no criminal conduct by the federal authorities. There was no evidence of a crime.
All right. And then what did you do after you got this report back from your people?
That was on August the 6th. A couple of days later, I saw the Attorney General in the hallway, and I said, Ken, there's no evidence of a crime. I recommend we close this investigation.
All right. When you hear that they're about to hire an outside counsel, what was your concern and your position?
My concern was that if Nate Paul wasn't going to cooperate, we shouldn't be doing the investigation. As I said earlier, I thought the whole idea of investigating the federal and state authorities doing this federal investigation on Nate Paul and essentially mounting a counterattack was ridiculous, was highly out of the ordinary, and was completely improper unless there was solid proof of a criminal act, and I didn't have that.
So what were you going to do by trying to get additional arguments as it applied to the hiring of an outside counsel?
Starting on August 12th, when I realized the Attorney General, who initially told me he agreed with me and then did a 180 and came at me in opposition to my idea to close the investigation.
You mean, are you referring to the third meeting?
The third meeting on August 12th.
Okay.
I was concerned the Attorney General was turning against me, that he might fire me because I wouldn't agree with what he wanted. And I was trying to find a way to prove to him that Mr. Paul's theories had no merit, and we had no business taking Mr. Paul's side against the federal authorities who were investigating him for criminal activity.
What was your attitude at that time, Mr. Penley, about the Attorney General in terms of what was motivating you here?
Well, I felt like he was under Mr. Paul's influence. I didn't know to what extent. That became clearer to me as things unroll and as we go forward in time. My concerns that he was either had been bribed or been blackmailed or somehow was being controlled by Nate Paul increased over time.
Well, let's talk about in terms of how you felt about him. Have you ever said anything about in terms of the subject of trying to protect him against himself?
I did tell him that. We had a very long conversation about that.
All right. When the Attorney General asked you to write down the names, did he tell you, and the documents, was it the documents he asked you to write down?
Yes.
Did he go ahead with the rest of that conversation?
He asked me to write down the documents. He asked me for Michael Wynn's phone number. Then the Attorney General told me that they weren't likely to give me any more documents because they didn't trust me. They didn't like the way the August 12th meeting had gone. They felt I was too aligned with Director David Maxwell. And then he said, I'll try to get the documents for you.
Well, on the 24th, where did you talk to him?
He called me on the phone. He told me he was at the White House. He said he just left a meeting in the Oval Office, and he wanted me to approve the DocuSign executive approval memo for the outside counsel contract.
What do you remember about that conversation?
I remember we talked for about 10 minutes, and that was the day that I drew the line with the Attorney General that I would not cross, and I never did.
What did you respond to the Attorney General?
I said, Ken, I cannot approve this, and respectfully, I will not. And I told him why.
All right. Would you articulate for the jury exactly what you told him as to why you were not willing to approve that contract?
I told him that Nate Paul and his attorney were not being cooperative with us by giving us all the documents that I believe they had. They had gone to the media, Furthermore, there was no evidence of any crime. We had absolutely no scintilla of evidence that any criminal activity had occurred on the part of the federal agents, the state agents, the federal prosecutor, or the federal judge. And I said, ethically, Ken, I can't proceed with this investigation, and I'm the senior prosecutor in the agency, and if it's not right for me to do it, it's not right for me to delegate it to anybody else. I won't sign this.
What was his response?
He said, well, we'll have to disagree on this. I've got to go to a press conference. We'll talk later.
Tell us in your own mind, and if you need to refer to them to remind yourself of something, but my questions to you are directed to what you planned to tell the Attorney General,
right,
in both tone and content for this meeting of the 26th.
Overruled. Continue.
Sir, what I planned to tell the Attorney General was, number one, this was a very dangerous investigation for him to continue. He was a friend of Nate Paul's. Nate Paul was a campaign donor to him. There was no evidence of any criminal wrongdoing. There was no legal basis to continue the investigation. There was no ethical basis to continue the investigation. In fact, I felt it was unethical to continue. I felt that Nate Paul was trying to manipulate me and Director Maxwell and the Attorney General to do an investigation that had no merit, and we shouldn't be doing it. And then I also told him there was great risk to him. This could look like bribery. This could turn into a criminal charge against him. I told him this could turn into a media scandal if it got out. I said, you should not be doing this. Please back away from this. Let me handle this my way. And then he made comments about his distrust of law enforcement and his concern about...
What did he say about law enforcement?
He said, you don't know what it feels like to be the target of a corrupt law enforcement investigation. I've spent $50,000 on my case, things of that nature.